gentlemen, welcome to the National Constitution Center's second virtual America's Town Hall. I am Jefrrey Rosen, the president of this wonderful institution. And friends, we must begin, as we begin all of our town hall programs, by reciting the National Constitution Center's inspiring congressional mantra. So recite along with me at home. You've done it many times when you've come to the National Constitution Center. If your kids are in the other room, they will know that you're doing something meaningful, if surprising. So here we go. The National Constitution Center is the only institution in America chartered by Congress to increase awareness and understanding of the Constitution among the American people. Beautifully said. And you can see the gorgeous virtual Constitution Center glimmering behind me. During these challenging times, the Constitution Center remains committed to bringing you the best historians and scholars and thought leaders in America to discuss all questions historical and constitutional. I told you last time, friends, that as students and teachers shift to remote learning, the Constitution Center is offering a series of live courses on the Constitution every Wednesday, Thursday, and Friday at 1 p.m. Please tune in with your kids or tune in yourself if you'd like some refreshers on the Constitution. It's been very meaningful for my colleague Curry Sautner and I to teach during these challenging times. It was so exciting to have Ken Burns with us last Friday, and the response has been great. So please do join us. It's part of your continuing duty to educate yourself as a citizen about the Constitution, and I hope it's a meaningful experience as well. We have some great America's Town Hall program. The Electoral College. On April 23rd, two authors about the presidential elections, and on April 28th, Yuval Levin about his important new book about how to restore trust in America's institutions, and there'll be more programs to come, so stay tuned. And now it is a great pleasure to introduce two of America's most distinguished constitutional scholars, two great teachers of the Constitution, and two old friends as well, who've written a really wonderful new book. It's called Democracy and Equality, the Enduring Constitutional Legacy of the Warren Court. And it's written by Jeffrey Stone and David Strauss. Jeffrey Stone is Edward H. Levy Distinguished Service Professor at the University of Chicago. He joined the faculty in 1973 after serving as a law clerk to Justice William Brennan. He's the author of so many totemic books about constitutional law. He wrote the case book that I use when I teach constitutional law, as do so many law teachers across America, as well as wonderful books about free speech in wartime, eternally vigilant, free speech in the modern era, and so much more. He also wrote the Interactive Constitution Explainer about the First Amendment. I've been using it to teach during our midday sessions. And David Strauss is Gerald Ratner Distinguished Professor of Law and Faculty Director of the Jenner and Block Supreme Court and Appellate Clinic at the University of Chicago Law School. He is author of The Living Constitution, a wonderful account of an alternative to originalism for those of you who would like it as a constitutional theory, and you'll be hearing more about those alternatives in our discussion of his new book tonight. Jeff, David, thank you very much indeed for joining.
Delighted to be here.
Thank you for having us, Jeff.
Let's jump right in with this great new book, The Enduring Constitutional Legacy of the Warren Court. Its title is Democracy and Equality, and in it you take 12 cases, totemic cases decided by the Warren Court, and we'll discuss them. And you argue that far from being examples of illegitimate judicial activism, as they're sometimes tarred by conservative critics today, they were in fact models of a principled jurisprudence rooted in a commitment to two big values, democracy and equality, and defended according to a coherent theory of the Constitution, rooted in a famous footnote from a case called the Caroline Products case. So if we can just jump right into that central thesis, Jeff, why don't you tell our audience more about what that footnote is, what its theory is, and how it justified and informed so many decisions of the Warren Court.
Well, before the Supreme Court's decision in the Caroline Products case, the court had used its authority to invalidate a wide range of legislation dealing primarily with commercial matters. And by the time the Roosevelt administration came to power, it became increasingly clear that this was not, in fact, an appropriate use of Supreme Court authority. And in Caroline Products, Chief Justice Stone, no relation, by the way, to me, in his famous footnote 4, essentially suggested that judicial review of an active form makes the most sense in situations where courts are most needed, and those two situations basically are democracy and equality. And what that means is it really goes back, in my view, to the framers who understood that democracy was a very good system, but it was an imperfect system. And there were a variety of ways in which it could be imperfect, but most important was that you couldn't always trust the majority. There were circumstances in which majorities would be overly self-interested and would do particularly two things. One is to not give adequate attention to the needs and interests of those groups within society who they regarded as the other, and who they did not, they were either hostile to or indifferent to. And second, that when in power, any group in particular would be tempted to use its authority to manipulate the rules of democracy so as to assure that they stayed in power. And footnote 4 basically identified those concerns. And our view is that the Warren Court was especially attentive to protecting those values against majoritarian abuse, and that their decisions, which are often challenged as being unduly or impermissibly activist, in fact, did exactly what the framers wanted the judiciary to do, which to put a check on these particular types of abuses of majoritarian power.
Thank you so much for that, for introducing the case so well and explaining footnote 4, which, as you said, is generally deferential to the political process, but less deferential in two cases that you identified, where the political process is closed or is malfunctioning, or when regulations adversely affect what the court called discrete and insular minorities. And the court, of course, added a third category too when a statute conflicts with rights explicitly enumerated in the Bill of Rights. So friends, that, as Professor Stone has explained, is the core of the Caroline Products theory. And we can now use it to understand how the Warren Court approached so many cases. Now, David, the most famous case decided by the Warren Court, perhaps the most famous case decided in the 20th century, is of course Brown versus Board of Education. You describe in the book how a concern with eradicating racial discrimination and its effects informed so much of the Warren Court. Tell us about that as a theme that united the Warren Court's decision, and why was it in 1954 that the court decided Brown and the Caroline Products case had been on the books for decades earlier? In some ways, this, you argue, was Chief Justice Warren's distinctive contribution. Tell us about the Warren Court and race and why you think it behaved in a principled fashion.
Thanks, Jeff. I think it is difficult to overstate the extent to which race, the concern with Jim Crow segregation, concern with the treatment of racial minorities generally, difficult to overstate the extent to which that was at the core of what the Warren Court did. And in a way, it remains, in a funny way, central to the Warren Court, because although, today you don't see any apologists for white supremacy or apologists for segregation, there were plenty of people back then who attacked the Warren Court in the most vitriolic terms because of what it tried to do to get rid of racial segregation and white supremacy. And that air that what the Warren Court was doing was somehow illegitimate, that it went too far, that it was too activist, that it was just doing politics, that maybe it was doing the right thing, but it wasn't doing law. All of that has kind of clung to the Warren Court since. And it was the apologists for segregation who were the first ones to attach those labels to the Warren Court. So in the beginning even in the 1930s, there were efforts by the NAACP and its affiliates to attack segregation. It's kind of hard for us today to realize how central segregation was to life in large parts of the country, where every institution you could think of was racially segregated. The litigation concerned mostly the schools, and by the early 1950s, the Supreme Court looked as if it was ready to take on frontally the question whether schools could be segregated. The specific doctrinal issue was, does separate but equal make any sense? Because the law said, well, schools have to be equal, but they can be separate. You can have a black school and a white school as long as they're equal. And the question was whether the Supreme Court was going to say what was apparent to anyone with eyes to see, that that's a complete fiction. In fact, it's a lie, and the schools of African Americans were not remotely equal to the schools of whites. So the Supreme Court first heard that case in 1952. It couldn't decide. It put the case aside and said, well, we need to hear more. We need to hear more briefs. We need to have more arguments. It specifically asked for people to talk about what the framers of the 14th Amendment, which is the amendment that the challengers of segregation, the civil rights groups, were invoking. What did the framers of the 14th Amendment think? In between that time, when the court first heard the case, and the next year, when it reheard the case, the then Chief Justice, Fred Vinson, died. Earl Warren was appointed to replace him. And the court, which had been divided before, was able to decide unanimously that separate was always unequal and that segregation had no place in American schools. And pretty soon the court made it clear that segregation of that kind had no place in American life. But a lot of people credit Earl Warren's skills as a politician for bringing the court together. And of course, Brown against Board of Education, which has become, as you said, Jeff, an iconic case. I mean, really, you can't be a mainstream lawyer in the United States if you don't accept the correctness of Brown against Board of Education. It was intensely controversial at the time. It's almost impossible to appreciate today how controversial it was. Today, it's seen as a huge triumph for the Supreme Court, for the Warren Court, for the Supreme Court, for American law, and really for America as a whole.
Thank you for all that. Thank you for telling the story of Brown so well and emphasizing its significance. Of course, I remember that comment of Felix Frankfurter when Fred Vinson died and in the middle of the Brown deliberations, he said, unkindly, this is the first evidence I've ever had that there is a God. And then,
yeah, I didn't want to say that, but yep, they had you.
I know, why not? I mean, it's part of the story. I mean, reminds us just of how the idea that our court is acrimonious today has long historical precedence. I see there are two questions in the chat already. So friends who are watching, do put your questions in the Q&A. And in the spirit of experimenting with this format, I'm gonna begin with Andrew McMahon's question because it's important. He says, noted progressive Professor Eric Siegel has said that some of the Warren Court's most sweeping decisions are abrupt and lack convincing reasoning. Do you agree with this criticism? He adds, please tell David he's one of my heroes, and he's not even a lawyer, and Professor Stone is great as well. That question about the Warren Court's decisions lacking convincing reasoning is, as Andrew McMahon suggests, central to the conservative originalist critique of the court. So let's begin with a particular decision. You have 12, and one of the most criticized decisions in terms of its reasoning was Griswold against Connecticut, the decision that recognized a right for married couples to use contraceptives. And the criticism of the reasoning went that William O. Douglas, Justice Douglas, was too freewheeling in his recognition of penumbras formed by emanations from different provisions of the Bill of Rights that created a generalized right to privacy, which laid found work for Roe v. Wade, but which conservatives and even some liberals charged lacked a clear rooting in the constitutional text. Now, there was a narrower opinion in Griswold. It was Justice John Marshall Harlan's notion that Fourth Amendment notions of the privacy of the home might be implicated by the kind of searches necessary to enforce the law. And also Connecticut was the only state of its kind, the only state in the country that had such a law still on the books. So in that sense, history and tradition might have allowed striking down the law on the grounds that it was really unusual. So it's a big question to you, Jeff, but does reasoning matter? Would Griswold have been more convincing and less controversial if Justice Harlan rather than Justice Douglas had the majority? And do you find the criticism of Justice Douglas's reasoning valid or not?
Well, I think that if I had been writing the opinion in that case, knowing what I know today at least, I would have relied explicitly on the Ninth Amendment. When the framers of the Constitution adopted the Bill of Rights, and they listed freedom of speech, freedom of press, freedom of religion, freedom upon reasonable searches and seizures, and right to counsel, and so on, one of the concerns they had, one of the concerns Madison in particular had, is that if you list a set of rights, that gives rise to the implication that there are no other rights than the ones that you've listed. And indeed, it's important to remember that the original Constitution did not include a Bill of Rights, in part for that reason, in part because of the concern that if you listed rights, that would create the implication that that's it. Those are the only rights that there are. And the framers knew that was not a good way to proceed. So when they finally did adopt the Bill of Rights later, they added the Ninth Amendment, which provided that the enumeration of certain rights in the Constitution shall not be taken to deny or disparage other rights retained by the people. It was an express recognition that if a right was not enumerated in the Bill of Rights, that didn't mean it was not a right of the people. Now, the challenge that posed is how do you then decide what is a right? What Douglas, I think, was trying to do in Griswold was to say that one of the ways of figuring that out is to look at what it is that is explicitly guaranteed in the Constitution and to draw analogies from those rights. And so he uses the phrase, the penumbras and emanations of the specific guarantees give rise to the understanding that the right of a married couple in the privacy of their home to use contraception is something that government should not be directly interfering with. So I do think that looked at in isolation, that seems like a somewhat arbitrary and random way of thinking about the Constitution. But I actually think it was rooted in the basic principle of the Ninth Amendment, that there are these rights that are not enumerated, but that are protected. And what Douglas was doing is looking at the other rights that were protected and saying, this is part of the enumerations of those other rights. I would have preferred he relied explicitly on the Ninth Amendment and said it in so many words. But the truth is the court has always been a little bit reluctant directly to invoke the Ninth Amendment because it opens up so much room that they don't quite want to go there. But I do think that Douglas's opinion was essentially that. And I do think that that's what he was doing in Griswold. And Arthur Goldberg, by the way, explicitly made the Ninth Amendment argument in Griswold in a concurring opinion. And in my view, that was probably the best of the opinions in the case.
Thanks so much for that. Friends, you're about to get a discussion with two of America's greatest common law professors about this fundamental question in common law. But David, I have to ask you what you make of Jeff's argument. So first he told us, the framers, when they put in the Ninth Amendment, said, don't assume if it's not written down, it's not protected. As a rule of construction, the Ninth Amendment says, don't do that. So there are some unenumerated rights that are protected. Then he notes you still need a theory about which unenumerated rights are protected. And he expressed some sympathy for the idea of looking at other provisions of the Bill of Rights and identifying the values that way. Do you agree with that, with that gloss on Douglas's opinion? Because the right to privacy, after all, is not clearly a right promoting democracy or equality, which were the two Caroline Products values. And the kind of privacy that the framers had in mind was certainly not one of sexual autonomy. That's a much higher level of abstraction. So I guess I'm asking you, are you as persuaded as Jeff by Douglas's general approach? Or if you had to write it, how would you write the Griswold opinion? And then how much do you think reasoning matters? Because that was the broad question that we're discussing. Would Griswold have been less controversial if it had been more narrow?
I guess, well, let me answer your questions in order, Jeff. I guess as far as Griswold, I'd come at it a slightly different way. And I have a little more, I guess I resonate a little more with Justice Harlan's opinion as he described it, which relied on tradition. And, tradition, of course, is a vaguely defined notion. There are all kinds of things that can claim to be traditional values. But I think that if I were if I were writing Griswold in a way that I thought made it most consistent with the central themes of the Warren Court, what I would have emphasized are some of the things you mentioned, Jeff Rosen, that here you had a statute, it was the only one of its kind, it was essentially not enforced except against birth control clinics, people who tried to sell contraceptives publicly. And when you have something like that, that just bears all the earmarks of a law that doesn't have full democratic legitimacy. It's a relic. Every other state but one has repealed it. Even in Connecticut, they weren't serious about it. And I think you can make a very good argument that that's the kind of law that in a democracy really shouldn't be on the books. And I would have been more inclined in that direction. As for the sort of more general question about how much reasoning matters, we say in the book that if you got some of the Warren Court opinions, if you're a law professor and you got some of the Warren Court opinions as exam answers, you might not give them such a good grade, and I think that is true. But what that really tells us, I think, is more about the role of the Supreme Court than about anything about the limitations of the Warren Court. Because I think in three respects, the Warren Court's reasoning was really exemplary. One is they didn't fudge it. And let me mention specifically the way they used the original understandings in the framers. In Brown against Board of Education, as I said, the court specifically asked the lawyers, explain to us what the original understanding of the 14th Amendment was. And they got extensive briefs from the lawyers and historians on that subject. It would have been pretty easy for them to pull out a passage here, a line there, a comment here from the history of the 14th Amendment and say, see, they also condemn separate but equal. There's enough there. It's murky enough so you can do that. And in fact, some scholars since Brown have tried to do that. The Warren Court didn't do that. They said, look, times have changed. There were virtually no public schools at the time of the 14th Amendment, or very few. It's a different world. We're not going to try to turn the clock back. And while you might say, well, that's a problem. If you say that's a problem, you're going to have to explain how you justify Brown against Board of Education. They didn't phony it up. They didn't try to bluff their way through and say, see here, the framers are on our side. When they got to a case about interracial marriage in 1967, it was the same thing. Virginia's law outlawing interracial marriage, Virginia, the only defense Virginia was willing to make at that point in 1967 was that the original understanding of the 14th Amendment was you could outlaw interracial marriage. And that is clearly true. It was clearly true in 1868 that no one was saying there's a constitutional right to interracial marriage. And the court, again, sort of just brushed that aside and said, look, we crossed this bridge in Brown against Board of Education. We're not going to talk about what they wanted in 1868. We're going to talk about where American society is today. That actually brings me to the second point I'd make about them, which is while they didn't write these kind of heavily footnoted opinions citing this and that, they really had a gut understanding of what I think is the most important thing to understand in the law, which is what direction is it going in? What is happening in the law and maybe in society more generally? And the Warren Court justices really did understand that. And contraception is an example, race is an example. By 1954, they were on very solid ground in saying, however comfortable people might have been with aspects of white supremacy 100 years ago, or even 50 years ago, or 20 years ago, we're moving away from that as a society, and it's time to take the next step. And they were very much in touch with that. And the third thing is the proof's in the pudding. And you look at those Warren Court decisions that at the time you could pick apart, and there were some law professors that did pick them apart and say, see here, this sentence doesn't follow from that sentence. Where is the support for this sentence? You look at them and, tell me which one is wrong. Is Brown wrong, or the school prayer case is wrong? Miranda against Arizona, vitriolically attacked at the time, now has as one of its fans the law enforcement wing of the current Supreme Court. So, they got something right. The test is, do these decisions last? And one thing about the Warren Court decisions is they have really lasted.
Thank you for all that. And that's a powerful challenge. Which cases exactly were wrong? You urge conservatives to identify. And I look at your list of cases and friends who are watching, here they are. Brown versus Board of Education. That's the case striking down school desegregation. Mapp versus Ohio, applying the exclusionary rule to the states and saying that states had to exclude evidence illegally searched and seized. Engel versus Vitale saying that the Regent's Prayer it could not be recited before public schools. Gideon against Wainwright, saying that there was a right to appointed counsel. New York Times and Sullivan setting forth the standard for free speech and basically repudiating any possibility of seditious libel. Reynolds against Sims, one man, one vote. Griswold against Connecticut, striking down the law prohibiting married couples from using contraceptives. Miranda against Ohio, we all know the rights from TV. Loving against Virginia, striking down bans on interracial marriage. Katz versus US, saying that there were reasonable expectations of privacy that could be triggered even without physical trespass in electronic searches. Shapiro and Thompson, the right to travel case, and Brandenburg against Ohio, that's the case that said that speech can only be banned if it's intended to and likely to cause imminent violence. So I recited that just so our friends know what the cases are. And Jeff, I'll ask you to kind of answer David's question. What were out of all of these, which do you think was most vulnerable in terms of its legal reasoning? I'll just, since I'm asking the question, I'll ask you. Katz is much criticized today. We all, privacy lovers, think that the court was right to find that electronic searches could trigger the Fourth Amendment, but that the reasonable expectation of privacy test has proved to be circular and unstable in terms of really protecting a quantum of privacy in an electronic age. So would you pick Katz or another if you had to identify the 12 cases you discuss whose reasoning you think is the weakest? And once again, if you had to write it differently, how would you write it?
I honestly don't think the reasoning in any of them is seriously problematic. I think that Griswold is the one that's probably most questionable for the reasons you suggested. Katz is an example where I think the court did a very good job. In Katz, the question was, what is the definition of a search? And at the time that the Fourth Amendment was adopted, people understood that a search was a physical intrusion into a physical space owned or controlled by an individual. So if a government agent broke into your home and searched it, or broke into your wallet or your briefcase or your car, if there were cars, that was the search. And the issue first came to the Supreme Court in Olmstead many years earlier, before Katz, which involved wiretapping a conversation. Basically, in Olmstead, a guy was in a phone booth having a conversation in which he was gambling, and the police, was that Katz? I'm sorry, that's Katz. Yeah, sorry about that. Olmstead is about telephone wiretapping. And the police wiretapped a phone call by Olmstead, and he was in his house, and basically the police wiretapped it on the phone lines outside the house. And the question was whether that was a search. And Olmstead claimed, you violated my privacy by interfering with and without probable cause or a warrant, listening to my phone call. And the Supreme Court, in a decision that was, I think, highly questionable at the time, said, no, it's not. A search is a physical intrusion into a physical space. And since the wiretapping was done outside the home of Olmstead, there was no search. And that remained the law for quite a long time. In Katz, the Warren Court overruled that. And in Katz, the Warren Court said that just in the same way that the government opened up a piece of mail that was sent by you or sent to you, that would be a search. And the government could not do that without probable cause and a warrant. And the Warren Court basically said, listening to a phone call is exactly the same thing in terms of the privacy of the individual. And that is a search. And then the question is, how do you define it? If a search can no longer be defined as a physical intrusion into a physical space owned or controlled by the target of the search, what is it? And the court struggled with this, and it came up with the idea of reasonable expectations of privacy, that individuals are entitled not to be searched in the context of situations which exist now, which didn't exist at the time the Constitution and the Fourth Amendment were adopted, but where technology in particular allows the government to engage in a search. So another example of this would be if two people have a conversation in a public park on a bench and a police officer hides in the bushes, that would not be regarded as a search at the time. But if you use a parabolic microphone from half a mile away to overhear that conversation, where there's no way to protect yourself against that, you couldn't look in the bushes. Basically, that arguably should be a search. So I think that Katz is another example of a case in which the court made a sound decision. Now, the problem is, what is a reasonable expectation of privacy? And as technology gets more and more advanced and more sophisticated, it becomes more and more difficult to figure out whether somebody does or doesn't have a reasonable expectation of privacy. And I think the court needs to continue to struggle with that to make it a bit more predictable as we enter the current world. But at the time that Katz was decided, I think it was a sensible and the best possible way of figuring out whether there was a search. Today, I think it is more complicated, and the court is struggling with coming up with another definition. But I think that was basically a very sound decision for the time.
Thanks for all that, and for that argument that given the need to come up with with a way of triggering the Fourth Amendment that didn't involve physical trespass, the reasonable expectation of privacy test worked for its time, even if constitutional law always has to be rethought, because that's one of both of your big theses, that in applying these basic principles like equality and democracy and privacy to changing times, the court plausibly and, in your view, correctly interpreted the Constitution. That still does leave the question of what the liberal method of interpretation is. And we've got a question from Nicandro Iannacci. Hi, Nicandro. It's so great to see your name. Nicandro was our great podcast producer who launched the We the People podcast. He's now a star student at Columbia Law School, and it is great to see his question, which I'm going to pose to David. Nicandro asks, how can progressives best defend the legacy of the Warren Court and promote progressive constitutional approaches to the general public voters? And how do we thread the needle between the usual conservative critiques and those of some young progressive leftists who may see constitutional law as ultimately limited and an even tainted project? That's a powerful question, which speaks for itself, and I'll let you answer, David, but I'll add to that. I'll present it to you by saying conservatives have a clear theory. They call it originalism. It was developed in part in supposed opposition to the a-textual, a-historical approach of the Warren Court. What approach would you offer up to young progressives as an alternative for originalism? What would you call it, and how can do you feel that it would be appealing to progressives who may be suspicious of the entire enterprise of constitutional law?
Well, it's a deep and complicated question, Jeff. And Nicandro, is that whose question it is?
Yes.
So let me sort of try to take it in a couple of parts. Progressive suspicion of, I wouldn't say constitutional law, but of the Supreme Court actually has very deep roots in our history. And for much of our history, the Supreme Court has been seen as a reactionary institution, no friend of progressives. That was certainly true in the run-up to the Civil War, when the Supreme Court was seen correctly as an instrument of the slave power. And the era that Jeff mentioned, the era beginning in the late 19th century and running up to the New Deal, same story. The Supreme Court was opposed to expansions of regulatory programs of the welfare state, and it was the enemy of progressives, and the progressive agenda emphasized judicial restraint, limiting the power of the Supreme Court. The Warren Court was an outgrowth of that, in the sense that both Jeffs outlined at the beginning, that the Warren Court's idea was, look, we live in a democracy, and the courts should not be deciding the big questions of public policy. They should not be deciding major issues about how the economy should function, how the Congress should regulate society. What the court should be doing is looking out for the people who are not getting a fair shake. Or making sure, the related idea, making sure, since we're a democracy, that democracy is working the way it should work. And courts should limit themselves to that. They should do that, but they should not do more than that. And our argument is that pretty much describes the work of the Warren Court. And the arguments the Warren Court was activist, that it was just a bunch of politicians in robes, are just 100% wrong. That the Warren Court had a deep appreciation for the democratic foundations of our society and really saw its role as perfecting democracy, not interfering with its operation. And I guess to the extent progressives today are not just disenchanted with the Supreme Court, and maybe they should be, but to the extent they're not, that the vision we should emphasize is that one. That the role of the court is to look out for the people who are not getting a fair shake and to make sure democracy is working the way it should. So should the Supreme Court be defending gun rights? Why? The question isn't should people have a right to have firearms and what should that right look like? That's not the question. The question is, why is that an issue for the courts? The political process seems perfectly able to deal with that question. And that's the way that these issues should be approached. And contrast that with the court's treatment of partisan gerrymandering, where last term the Supreme Court said, no, we're not by a 5-4 decision over a strongly worded dissent by Justice Kagan. The Supreme Court said, no, we're not getting into that. That's too complicated. And I think our view, the progressive view, and I think, the right view, is no, that's exactly where you should step in. That is, what are the courts doing if they're not stepping in there? Here you have a problem that goes to the heart of democracy that the political process by its very nature can't solve because you're asking the people in power to put themselves in a position where they can be voted out of power. That's exactly what the court should be doing. Not protecting gun owners, not protecting majority groups against affirmative action. Majorities are majorities. They can, if they want to scale back affirmative action, let them resort to the political process. They should not be invoking the courts. If they win in the political process, they win in the political process. But I think that's the most promising approach for progressives. Having said that, and I think this may be a point on which Jeff and I might not completely agree. I don't know to what extent the Warren Court really can be seen as a model or a template as opposed to something that happened at one time in our history and will be very difficult to recreate. I mean, in my optimistic moments, I think the latter, that we can. But sometimes I wonder, given how often the Supreme Court has not been a progressive institution, whether the progressive skepticism that you, Jeff, referred to about the Supreme Court really is a justified position.
Thank you for that. Jeff, tell us more about that interesting skepticism that he identifies, and he suggests that you may be more or you may have more of the orthodox faith in the court as a defender of rights and offer up the Warren Court as a model. And then tell us, building off your last chapter, what kind of cases on the current court would come out differently if it were to adopt the theory that you and David urge of promoting democracy and protecting equality. You note at the end of the book that Heller certainly would have come out the other way in not recognizing a right to bear arms because there was no political process failure, but you suggest that Citizens United would have come out the other way and the court would not have struck down restrictions on campaign finance. Say more about why Citizens United would have come out the other way. You could probably argue it round or flat when it comes to democracy reinforcement. And then tell us whether there are other earlier cases in the campaign finance arena that might have come out the other way, including perhaps Buckley versus Vallejo and the original campaign finance case. And basically, if you were deciding the campaign finance cases from scratch in a Warren Court-like way, how would you decide that?
So to begin with, I should say that I truly do believe that if the Supreme Court consisted of justices who understood what I believe to be their fundamental responsibility in interpreting and applying the Constitution, which I do believe is neutral in the sense that it's not about being a Democrat or a Republican. It's about protecting minorities, protecting those people who in our society are vulnerable to majoritarian abuse, including people accused of crime and women and gays and religious minorities. And on the other hand, ensuring that we protect democracy from the manipulation by whatever party is in power at any given moment in time. I think that justices who understand their responsibilities through that lens would make the Supreme Court a truly positive and essential mechanism to preserve the core values of our society and our Constitution. I think one of the reasons we've had the problems we've had in recent decades, and one of the reasons why progressives have often lost faith in the court, is that 14 of the last 18 justices appointed to the Supreme Court have been appointed by Republican presidents. And that's despite the fact that Republican presidents have won the popular vote in only 3 of the last 7 elections. And beyond that, they have become increasingly ideological in their selection. And justices like Sandra Day O'Connor and David Souter and John Paul Stevens, who were appointed by Republican presidents, were much more moderate than the current 5 justices in the majority. And I think that from the standpoint of progressives who's grown up in that world and who've seen the court from that perspective, can understandably take the view, look, the Supreme Court does not protect democracy. It does not protect minorities. It basically implements the values and the wishes of the Republican Party. And so why should we give the Supreme Court power? And I think I understand why they feel the way they do. But you know, if Merrick Garland had been confirmed, as he should have been, then we would have had a court with 5 justices who would have been much more understanding of the core values of the Warren Court, and a court that would have been, in fact, doing what should be its role in our society. But I do understand that people who've grown up in the last 25 years as adults would be not very confident in the court because of the way it's been constituted. Now, in terms of the campaign finance issue, I think at the time of Citizens United, the right approach was that of the 4 dissenters in the case. And that the concern there was that the role of money in the political process had become so overwhelming, partly because of the ways in which it could be spent far more effectively and far more influentially than it could have been in the 19th century, say, that they understood that money should not be what determines the outcome of the political process. The billionaires in our society should not be the ones who ultimately decide who our elected representatives will be. And therefore, doing what the legislation that was at issue in that case, McCain-Feingold, a law that was enacted by John McCain and Russ Feingold, a Republican and a Democrat, and was signed into law by President Bush, right, which was meant to correct a really serious dysfunction in American democracy, should have been upheld. And yet the 5 Republicans in the majority said no. And the reason they said no, in my view, is because this law would have impaired the power of Republicans to control the political process, because they were largely the beneficiaries of the billionaires. And in that case, I think there's a pretty clear, correct answer. And the court divided in a very ideological way in the case, based upon Republicans and Democrats, which is unfortunate, but that's what happened. At the time of Buckley v. Vallejo, to answer that question, I think the justices were more divided, and including the liberal and conservative justices were more divided, because at the time of Buckley, in the early 1970s, the role of money in the political process was not nearly as dominant as it became by 2010. And that therefore it was easier to see, well, should the government be in the business of manipulating the political process? And that's not a good thing. And so they were more skeptical about government regulation. But by the time we got to Citizens United, it was clear that the effect of the billionaires on our government and our democracy was destructive. And the legislation should have been upheld, and we would have had a much better democracy today if that had been the case.
Thank you for all that. Friends, I need to say now that if you're getting CLE credit, continuing legal education credit for this wonderful conversation, and what better way to get CLE credit, go to the Q&A box and you will find the thrilling secret code that I can't announce here because people might see it on YouTube, and you'll find it and you can get your credit. So thanks for joining for CLE, and check out the Q&A box for the very cunning and extremely sophisticated secret code. David, there's a nice question from Jessica Leeton, who says, I see in your bio, David, that you've argued 19 cases before the Supreme Court. Which argument from your experience stands out to you the most, or in which case did you take the most pride?
Oh dear. Well, I will say, all my clients in all of those cases were totally on the side of the angels, and their position in every instance was 100% correct. And when we prevailed, I congratulate the Supreme Court for its wisdom. And when we lost, I think all 9 justices should be, or at least the ones who voted against this, should be impeached and removed from office. So I guess that's my position. Let me answer sort of this way, in a way that might actually be more useful than the nonsense I just spouted. One thing about Supreme Court arguments that I found that I would not have thought is often the most satisfying ones, and the ones I sort of took the most pride in, the sense that the ones I thought I actually accomplished something in the argument, were not high-profile cases. They were often kind of obscure cases. And the reason that was satisfying is the justices didn't know what they thought. If it's a high-profile issue, if it's capital punishment or abortion, I didn't argue any of those cases. But cases like that, high-profile issues, search and seizure cases, Miranda cases, some of which I did argue for the government, they kind of know what they think going in. And there might be some wrinkle that they haven't quite thought of, but you're certainly not going to shake their core views about an issue like that that's very high-profile, they've thought about for years, and they've voted on and written opinions about. You're not going to produce a radical change in their minds. But if it's a provision of some statute that they've never thought about before, and they are genuinely puzzled about, and it doesn't have particularly ideological connotations, you can actually accomplish something as an advocate and work your way, sort of work through some issues with them and try to persuade them. And you really sometimes have the feeling that you made a point and they recognize it and they understand it, and you've kind of won over a convert to your side. And sometimes you try and you look in the eyes of the justices you're trying to persuade, and you realize that, nope, that didn't work. I gave it my best shot, but nope, I guess we're not going to win this case. But in an odd way, for me at least, the cases that when you first come upon them, you think that's not that interesting, that's kind of a dog. When you get into it and have a chance to argue it, often can be more satisfying for just that reason.
Thank you for that. Justice Breyer has said something similar, but it's in the more technical cases that he finds the justices have open minds and discussions are more interesting because they can persuade each other, and a great advocate can obviously help it just the way you suggested. Jeff, we have a question about the pandemic and restrictions on civil liberties. You've written, I would say, the definitive book on civil liberties in wartime. Friends, if you're watching, check out Jeff's book on civil liberties in wartime. And Heather Bickley asks, the country has reacted to the pandemic with restrictions on freedoms that most Americans would never accept in any other situation. Also, the current situation has shed a big light on the racial and socioeconomic inequalities in our country. What can we learn from the Warren Court to protect our freedoms and move toward a more equitable country as we continue in the current and post-pandemic world?
That's an interesting question. I don't know what policies have been enacted that would be, right now at least, would be seen as unconstitutional. Maybe David has some views that I'm not thinking of. One interesting one has to do with the right to travel, which is that the Supreme Court has recognized from way back in the beginning that individuals have a right to travel interstate, that this is one nation, and that for a state to tell people who live in or come from another state they may not enter has been regarded as a serious intrusion upon one of the central fundamental rights of this being a single nation. And obviously, a range of different states have put in place constraints on that, either banning it altogether or saying you have to be quarantined if you come from a state which has more of this pandemic than our own state does. I think some of those raise interesting questions about whether they're constitutional, particularly when the state does not impose the same restrictions on its own citizens that it imposes on citizens from other states. And I don't know that there's been any litigation yet about that. And I think it is a tough question because these are serious times, obviously, and the risks are very high. But that's one situation. There's a obvious possible search and seizure type of problem, which could arise with tracking individuals, seeing if they leave their homes or if they go into public places they're not supposed to, or also just arresting people for going into settings that they've been prohibited to go into, like public parks today and so on. But unless I'm missing something, so far I haven't seen any major constitutional issues that arise from these actions. But I may be missing something.
Thanks for all that. We did a great podcast on this last week, and our crack experts agreed with you that most of the quarantine-like action would not raise constitutional issues based on precedent. There is a case coming out of Texas involving restrictions on abortion. Texas has said that only abortions necessary to save a woman's life can be permitted and others can't. So I guess, David, why don't I ask you your views on that case, if that were to go up to the court. How should it be decided? And maybe in the course of thinking about future restrictions on the right to travel, tell us about the reasoning of Shapiro and Thompson, the right to travel case that you described. It didn't squarely it rooted in the privileges or immunities, privileges and immunities clause, but not squarely invoking history. So do you imagine a Warren court today being more sensitive to some of the socioeconomic effects that Heather mentioned, with restrictions on the right to travel, and possibly challenging President Trump more than this court is likely to do?
Well, on the abortion issue, I think if Roe against Wade is the law of the land. You have a constitutional right to an abortion, and the only issue would be whether circumstances are so exigent that you can effectively just deny that right to a woman, and I don't see the case for that. I mean, at least as long as any other non-emergency surgery or surgical procedure is being allowed, I don't see the case for it at all. And even if there isn't any other, you don't have a constitutional right to most forms of medical care. You do have a constitutional right to this one. As long as you do, I think the state can't forbid it. Now, what this court will actually do, of course, that's unfortunately a different question. On Shapiro against Thompson and the right to travel, it's a very interesting question, Jeff. So thank you for that. Shapiro against Thompson came right at the very end of the Warren court. Here was the issue. It was a so-called durational residency requirement, which is a mouthful of words that means that some states had said that if you just recently moved into the state, you can't get welfare benefits from that state. The Supreme Court said that was unconstitutional. The opinion is, it's another one of these opinions that they were really onto something, but when you try to piece together the opinion, there are some gaps in the logic. The opinion sort of melded together the idea that you have a right to travel state to state, and if you're going to lose your welfare benefits when you move from one state to another, that interferes with your right to travel, which is true in a sense, but it would mean that a state would have to treat all new residents the same as longtime residents, and no one really thinks that about everything. But it added to that the idea that, look, these are welfare recipients, these are poor people, these are people who are trying to get not, a fishing license or something like that, but the means of survival, and that should play into the decision too. And the court sort of melded those two ideas together. And what was interesting about Shapiro against Thompson, I think, is this. The Warren Court, as we've talked about, was really intensely focused on the problems of race discrimination. By 1969, at the very end of the Warren Court, while obviously that problem had not been solved, it was clear that the very worst days of Jim Crow segregation, of officially mandated segregation, were over, and that the remnants of that regime were on the run. There was obviously plenty of race discrimination still, but that at least that the core of the white supremacist regime had been effectively, if not eliminated, then effectively curbed. So what was the next subject? And the next subject was, in the minds of the justices, was poverty. After race, what about poverty? Isn't that a lot like race? Here you've got a group of people, they're outcasts, no one takes them seriously, they don't have their fair share of political power, they're stigmatized, they're subject to prejudice. And Shapiro against Thompson was the first halting step that the Warren Court was taking it took a couple others sort of right around that time in trying to address the problem of poverty by saying, you know, it's one thing if a state says, if you want a license to set up a corporation, you know, you can have to, we want you to make sure you've been in the state for 90 days. It's quite another thing if they say, if you need the, if you are looking for the money you need to survive, we're not going to give you that for 90 days. And that was the beginning of a sense that the Constitution should address problems of poverty. That line of cases really went nowhere. The right to travel has survived in a form, as you said, Jeff, it has been linked to a clause in the 14th Amendment that otherwise no one pays any attention to. It's the privileges or immunities clause of the 14th Amendment. Shapiro against Thompson was really based on a different clause, the Equal Protection Clause, the one that's used for race discrimination, excuse me. So the right to travel survives in some form. And I agree with what Jeff said, that probably in these extreme circumstances, you could at least make an argument that a state could limit the right to travel if it did it in a neutral way, although that's a very difficult issue. But it only comes up once in a while. It's not an everyday issue. And I don't know that the Supreme Court would want to get involved in that. Conceivably, they would. I think one issue that, you know, if you followed the approach that we advocate in the book, you would see the court getting involved in is the effect that all of these shutdowns have on voting, which is potentially hugely important. If people are afraid to go out and vote in person, do they have a constitutional right to vote by mail?
I'm getting David freezing, which may be a Zoom issue, so I'm going to jump in and thank you for the question. I hope you'll come back virtually in a sec. But as it happens, we're out of time, and it's very important in the Zoom age to end on time. So friends, thank you so much for joining this rich constitutional conversation. And please use this challenging time that all of us have at home to learn and read and stretch your minds as much as possible. So we've got some great homework. The first, of course, is Jeff and David's new book, which is Democracy and Equality, the Enduring Constitutional Legacy of the Warren Court. Then pick one book each by Jeff and David to read. You could start with David's The Living Constitution and Jeff's, well, Free Speech in Wartime. It's just such a great book and so apt to these anxious times. And finally, if you want extra credit, not for CLE, but just for the pleasure of challenging yourself, read one of the 12 decisions that they talk about. You could start with Griswold versus Connecticut, the one we talked about. Read all the decisions, the majority opinions, as well as the concurrences and the dissents. And then write to me and tell me which opinion you found more persuasive, jrosen@constitutioncenter.org. It will just be a form of mental gymnastics that will stretch your faculties and challenge you to engage with the really important arguments that Jeff and David have presented with us, which is to think about the effects of democracy and equality on the Supreme Court. Friends, these Zoom sessions are so meaningful for all of us at the Constitution Center to offer up. We hope you'll join us on Wednesday at 1 for our live constitutional class, and we'll hope to see you again at our next town hall later this month. Stay safe, everyone. Thank you so much, Jeffrey Stone and David Strauss.
Thank you, Jeff.
Thank you. Bye, everyone. See you soon.